Uh, Today is the date and time set for an arraignment. Go ahead, counselor.
For purposes of arraignment, my client stands mute.
Enter not guilty plea on his behalf. Give him a $0 bond.
Line from the judge, if you don't talk, you just might walk, is gold. It's basically a courtroom survival tip. The more you speak out of turn, the more you help the prosecution. And Lopez doesn't seem to get that lesson at all.
It appears that we're having trouble running driver's license, period, with the system seems to be down, apparently. Mr. Lopez off the record indicated that he had a valid driver's license. He also has a careless driving. I have an allegation that reads on the record that Mr. Lopez apparently is driving and operating a, I don't know if this is a crotch rocket or not.
Super bike.
Hold on a second, sir. So if you interrupt like that and you say, I always say this, if you don't talk, you just might walk.
Okay.
That's the line for the day. And
this part is almost comical. The defense is trying to clarify what kind of motorcycle Lopez was riding, but Lopez can't resist chiming in. He objects to the words, crotch rocket, or super bike. And the judge's patience starts wearing thin. Here's the problem, when you're the defendant, these small interruptions only make you look argumentative and unfocused.
So, it says here, Ms. Harris, that Mr. Lopez was riding this super bike. Is that what you said, super bike?
It's a motorcycle. It's just a motorcycle.
What is a super bike?
I don't like the stereotypical name that it got the first time, so just a motorcycle.
Wait a minute. So you have a problem with them calling it a crotch rocket?
Yeah.
But you're caught up in semantics, huh?
Yeah, it's just a motorcycle. It's just a motorcycle.
Well, you got different kind of motorcycles. Is it a dirt bike, one of those 250 dirt bikes, or is it one of those 1,000 racing bikes? What is it?
Yeah, it's one of those.
So
Your Honor, can we not have him answer all these questions?
Well, yeah, he already mentioned it. I didn't. He already said that. I'm trying to. Okay, anyway, I'll go digress on that.
This is where Lopez really starts digging his own grave. He insists he was wrongfully convicted before, and that he's a careful driver. But instead of letting his attorney argue for him, he blurts it out directly. The judge even tells him point blank, "You talk too much, sir." That's a brutal reality check.
You knew that?
I didn't know that.
So, this is like one of those, maybe he needs to take the better driver's course. Let's see if you have a driver's license in hand, sir. Do you have a copy of your driver's license with you? Obligations, Miss Harris. Join the breakout room.
He has a cycle endorsement also.
Yeah, I have an endorsement.
Now, I don't know if it's valid, but it does read that.
Yeah, it's valid.
Yeah, that's what you say. I don't know. I don't know if it's valid. Hold on.
Your Honor, I'm very careful when
he likes to talk. Go ahead.
I feel like I was wrongfully convicted for that. I'm very careful when I'm driving. It's just I don't know, the officer just I know what it looks like.
We need to set a trial date.
No, I don't need a trial.
Join the breakout room, speak with the lawyer. You talk too much, sir.
Okay.
This moment is key. Lopez is asking about a plea offer, but in the same breath, he claims the officer lied. You can't have it both ways. A plea means admitting guilt. If you deny the charges, the judge can't accept a plea because there's no factual basis. And the judge gives a sharp warning about buyer's remorse, defendants who plead guilty, then regret it later when their license gets suspended or insurance skyrockets.
So let's go back on the record with Mr. Lopez. He indicated to the court that the officer essentially, he didn't, what I understood, he didn't do what the allegations suggest. So that leads me to having to set a trial date. Yeah, I can allow you to respond to that.
Do I think a trial would be in the best interest? Yes. However, my client wants to know what the current offer would be.
Yes.
Well, again, you know, Mr. Lopez, you want the offer, but in the same breath, you say that the officer wrongly wrote you the ticket. So how are we going to make a factual basis, an active factual basis for this type of charge when you're not prepared to admit to it?
This ends on a dramatic note. The judge sets a firm trial date. Lopez blurts out, "Jesus Christ," in frustration, and the judge immediately checks him again. It's a perfect example of why staying quiet can sometimes be your best defense. Lopez walked into court for a traffic case, but his own words turned it into a full-blown trial.
You're not going to come back in here, and I already have enough of these. What is this here? Request to withdraw admission. I have enough of these. One is sitting here on my desk right now. What I call buyer's remorse. After you go plead guilty, then you get the points on your license, and then they mess with your chauffeur's license. Now you want to come back to the court and say, you know, something, I didn't know my rights, or I want to do this, is affecting me in this negative way. So I'm not going to do it. I'm going to set a trial date. You know, that's another thing. When you talk like you do and you keep on talking, then that's what happens. So when people interject, like you just did, and said, I believe, superbike, then that just checks off one of the things that the prosecutor doesn't have to prove anymore. You understand where I'm coming from, Mr.
Yes,
Lopez?
I hear you. Yes, I hear you,
All
Your
right.
Honor. I'm sorry.
That's all right. That's all right.